Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Gu, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor and or felony, punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself in this. You have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If for whatever reason during any point in this proceeding you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that you understand English. You believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth.
Mr. Mio has returned, and he's about to learn the hard way why legal representation isn't optional but essential. If this is your first time on the channel, this is actually part 2 of a case we previously covered, and let me just say Daniel Mio has not made any progress since then. He continues to ignore Judge Simpson's questions, carries himself with an air of arrogance, and somehow still believes he's above the system. From the moment this hearing started, it was clear Mio was off to a terrible start. It's awkward even saying his name, but that aside, his behavior in court speaks volumes. Imagine showing up without a lawyer and then chewing gum during the proceedings. That's exactly what Mio did. Let this be a warning. Do not follow his example. Legal counsel is not just a good idea, it's absolutely necessary. With that said, let's get into today's hearing and see exactly how things unfold between Mio and Judge Simpson.
And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or a prelim.
You wish to have a preliminary examination?
Preliminary examination. Yes, sir.
Would the people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, complete discovery to the defendant, and I believe that some of the representations that were made in this writ of mandamus that has been dismissed include appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion with no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping that to sort of reconcile both of those things as whether or not discovery is something the defendant's prepared to move forward, and if he ever has filed a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So If it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against.
I'm going to indicate discovery is complete because I don't know what you're saying. Because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion on, or the motion will be heard on date of exam. We'll
Thank you, Your
deal
Honor.
with it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12.
Yeah.
12 noon, that is before me.
Thank you, Your Honor.
And continue.
Here's a rewritten version of your commentary in a more polished, articulate, and sharp tone, while keeping the original spirit intact and eliminating commas, periods, and other punctuation as you requested. This individual is a textbook example of why legal representation is not optional, but absolutely critical, and beyond that, the way he carries himself is wildly smug, as if he genuinely believes he can outsmart a judge, which is baffling in itself. If anyone in the comments can explain why someone would behave this irrationally, I'm open to theories, because to me he's giving strong sovereign citizen energy, and if you followed my channel you know I've covered quite a few of them. They all share that same overconfident delusional air. They posture like they're somehow in control while staring down serious charges, and they constantly talk down to judges as if they're the ones running the courtroom. This guy is currently facing charges for assaulting a police officer, and on top of that he lost custody of his child. That's not something that happens on a whim. That's a serious legal consequence with real implications. And yet he walks into court as if this is some routine errand, tossing around denials and acting completely indifferent to the situation around him. It's not just careless, it's dangerous, especially when you have no legal defense and no strategy other than pretending the court has no authority over you. Watching this play out, it's clear the judge is losing patience, and honestly, I think most people watching feel the same. This is not how you handle serious charges, and it's not how you protect your future. Representing yourself almost never ends well, and time after time we've seen it only makes things worse, especially when the person doing it is more focused on being defiant than being smart. And let's not ignore the deeper issue here. This man lost custody of his child, and while I don't know all the details, I do know that courts don't make that decision lightly. It speaks volumes about the situation. And yet here he is treating the entire process like a game. It raises real questions about his mental state and honestly his fitness as a parent, because nothing about this behavior suggests maturity or stability. That wraps up my thoughts on this clip. I'll be covering the next hearing in January once it's released, and based on what we've seen so far, I'm expecting it to be as wild as ever. If you're enjoying the content, a like and subscribe would mean a lot to me. It really helps the channel grow. Thanks again for watching. And as always, take care.